Good afternoon, everyone, and welcome back to Criminal Law. This is Chapter 4, Criminal Liability. So what constitutes criminal liability? When we're talking about the committing of a crime, the stages of those crimes, there's different actions that can amount to criminal liability, such as planning the attempt, solicitation of others to help you in the committing of that crime. And so any party associated with the plan or the attempt to commit a crime can be criminally liable for that crime. So this is kind of a complex diagram, but we'll get through this pretty easily. On the left-hand side is just the original idea for committing the crime. We do have there are not crimes against thoughts alone. So thoughts alone can't justify charging someone with a crime. The next stage is where we start getting into criminal liability. That's the planning and preparation stage of the crime. And this can include crimes of solicitation, where a person may solicit another to commit a crime. Conspiracy, ordinarily, they're usually charged in the planning and preparation stages. That conspiracy being between two or more people, where a single person is only required to commit the crime. Then you've got the attempt of the crime, is that third stage, and that attempt cannot be charged until the attempt can be clearly shown by the state that the attempt was there to commit the crime. And then you actually have the commission of the crime. So the completed crime should not be charged until the state can show all of the essential elements, so that was 2 chapters ago, of the completed crime. So until the state can show that, then you don't have a completed crime. And then for another day, we'll talk about post-crime offenses such as aiding and abetting and those type of crimes. So we'll talk about those on another day. On the last slide, I said that intent to commit a crime wasn't a crime in and of itself. Today, this slide, I'm actually going to show you where it can be. So it is possible to commit a crime based on the stated intention, even though the person making the statement was joking. So the 18 USC 35B was the bomb hoax statute, and it makes it a crime to make a false statement about the presence of a bomb in a civil aircraft. Because of the need to prevent serious social harm before it occurs, courts created the 3 separate and distinct common law crimes of solicitation, conspiracy, and attempt. And all these offenses are crimes in and of themselves, but they are acts in preliminary or anticipatory to a more serious crime that the offender has in mind. These anticipatory crimes are commonly referred to as in-choate crimes, crimes that are not yet completed. Therefore, the events surrounding a crime can constitute criminal behavior in and of themselves. So if that sounded confusing, I'm going to try to clear it up here. When and where does non-criminal conduct become criminal conduct by a further act of the suspect? So which of the preliminary offenses, if any, has the suspect committed? And when does the commission of the principal offense begin? So as to allow the state to charge either the preliminary offense or the principal offense. So the preliminary offense could be the solicitation of a criminal offense, because the carrying out of that criminal offense never needs to take place for the crime of solicitation to be charged. I was a little quick on that last slide. Here we actually are talking about solicitation and the fact that there does not need to be the completion of the actual primary crime. The preliminary offense of solicitation in and of itself is a criminal offense. The purpose of making solicitation a crime was to prevent crime, to protect the public from criminal inducement, to permit society to identify and deal with persons who show that they're dangerous to society. Conspiracy crimes are agreements between two or more persons to engage in unlawful acts. These are the oldest of the preliminary crimes. They can be traced back to about 1300 AD. The agreement constitutes the act in concurrence with the mental intent to actually carry that out. So even if the planned crime, the primary crime, is not attempted, the agreement constitutes the crime of conspiracy in and of itself. So under common law, there was a requirement that both conspirators must have the guilty mind. It was called two guilty people. An example was A solicits B to rob a bank. If B agrees but secretly intended to call the police, there was no actual bilateral agreement or meeting of the minds on the actual attempt. So that would, in that case, A would not have been guilty of solicitation because B was not intending to carry that out. So there was no bilateral agreement. However, present unilateral approach under the Model Penal Code gives in the example above, A can be convicted of conspiracy even though B never intended to carry out the whatever the crime was, the bank robbery that B was going to commit. So both conspirators need not be charged or tried. So example, A and B conspire to kill person C. A can be convicted of conspiracy even though B can't be found, or B is dead, or B is not charged. Oftentimes what you'll see is B might have turned state's evidence against A, and in return B doesn't get charged, but A gets charged for the conspiracy. So in a conspiracy where the existence of two people must exist, husband and wife can satisfy the two or more persons requirement. And interestingly enough, corporations can actually conspire, but it still requires two human agents to be involved. So Corporation A and the CEO of Corporation A cannot be convicted of conspiracy unless another person is involved in that conspiracy crime. So you may remember that a couple of slides ago we were talking about criminal conspiracy, and I said that two or more people conspiring to commit a crime in and of itself is a crime. Well, that's the way that the historically has been. The criminal partnership was all that was required to prove the crime of conspiracy. There was no requirement for the prosecution to prove that some overt act was done in furtherance of the conspiracy itself. However, today, most states require proof of an overt act by a defendant, as we do here in Maine. The overt act need not itself be a criminal act, but the overt act toward the commission of the primary offense. So an example would be buying a ski mask to be worn during a robbery satisfies as an overt act. Almost any overt act satisfies the act requirement. It's kind of funny that we're all wearing masks today because of COVID, but buying a ski mask going into a bank would have never been acceptable prior to this. So just an interesting fact. So we've talked a little bit about RICO prosecutions, and RICO prosecutions involve some sort of corrupt organization or the conspiracy to commit a crime is often considered in those RICO prosecutions. So in Salina v. the U.S., a person could be convicted of the conspiracy without having taken any acts, so long as he agreed to participate in the underlying crime. Whitfield v. the United States says that some statutes do not require an overt act, but only agreement to participate. So an overt acts are often very convincing evidence of the sincerity of a conspiracy agreement, and almost all strong conspiracy cases do have the evidence of overt acts in them to bolster that prosecution. So the Wharton rule is very interesting, and one that you're going to want to know. Some crimes cannot be committed alone, but require two or more people for the commission of the crime itself. So the primary offense requires two or more people. If that's the case, the conspiracy is not typically charged unless there are more people involved in the conspiracy than are involved in committing the actual crime. So, for example, gambling, prostitution, receiving a bribe, and distributing illegal drugs, all of those crimes require more than one person. So if we look at distributing illegal drugs, you have the person selling the drugs, you have the person receiving the drugs. So that has the requirement of two people. So if you have three people involved in the conspiracy to distribute those illegal drugs, then you can have a conspiracy. The Wharton rule just says that you must have more people involved in the conspiracy than are actually required for the under the primary offense. So this is an interesting case. United States v. Jimenez Recio. The court reversed a Ninth Circuit Court of Appeals decision. This is the U.S. Supreme Court, overturned the Ninth Circuit, that conspirators could not be convicted of the crime if the object of the conspiracy had been defeated before the defendants had joined the conspiracy. So this was the defendants arguing that since the object of the conspiracy, the possession of illegal drugs in this case, was made impossible by the drug seizure by the police, the conspiracy was over before it even began. The High Court, the Supreme Court, stated that the essence of the crime is the agreement to commit a crime, not the crime to be committed. So it's just that essence of the crime that the conspiracy involves. So it doesn't necessarily have to be a crime that can be committed. It just is the intent to commit the crime. Even if the conspiracy is abandoned or one conspirator withdraws from the conspiracy, the crime of conspiracy is complete. Since the crime is complete with the agreement, no subsequent action can exonerate the conspirator of that crime. So if one conspirator withdraws from a conspiracy outside the limitations period, so the time to actually complete the crime, and in most federal prosecutions, the federal government says that that time is 5 years from the time of the criminal conspiracy, the actual crime has to take place. So outside of those limitation periods, the prosecution for conspiracy, the withdrawal bars that conviction. So if the person withdraws after 5 years, that withdrawal bars the conviction of that person from the conspiracy. But they would have been barred from the conviction anyway because the limitation had expired. The crime of attempt is the most frequently charged of the three preliminary crimes because near victims and witnesses generally report attempted rapes, attempted robberies, attempted murders. So even if the crime was not actually carried out, an attempt poses criminal liability for the offending party. Intent plays a role in attempted crimes as well. So where a base crime has specific intent, attempt must have the same intent. So you must have the same intent as the underlying crime that you're trying to commit. The criminal act of attempt, or the actus reus of attempt, states can differ on. This act requirement is an attempt. An attempt is defined, however, by the substantial step test, which we'll go over in just a second. The dangerousness of the criminal is the focus of this test that we're looking at. So the substantial step, a person is guilty of an attempt to commit a crime when, with intent to commit a crime, he engages in conduct which tends to affect the commission of such crime. So the example the book gives was gathering addresses of witnesses, arranging for financing for a hitman, and sending a letter to arrange for hits on witnesses constitutes substantial step in attempted murder. The concept of impossibility in attempt is a fairly interesting endeavor. So most courts reject any defense based on any factual reason why the attempt could not be successful. So the gun wasn't loaded, the illegal drugs were fake, so the attempt would have been impossible. Most courts agree it is still an attempt if the circumstances were as the person believed them to be. So if they believed that the drugs were real as they were attempting to sell them, that attempt is still valid. If the person thought that there was bullets in the gun, then it was as they thought it was. So that impossibility of the crime does not take away from the attempt. It doesn't matter if the conspirators change their mind, just like we saw in the last case, abandonment or withdrawal. Conspiracy crimes are complete when the criminal agreement is reached. All right, let's talk parties to the crime principles now. Parties to the crime, the principles are generally the people who participate in the crime itself or are otherwise involved in the commission of the crime are liable as principal parties. So the principal in the first degree has historically been known as the person who actually commits the crime. The principal in the second degree is historically known as the person who were present at the commission of the crime, but was not involved in the planning of the crime, but aided and abetted in the actual commission of the crime. And then finally, an aider, abettor, or conspirator, a person could be criminally liable for the conduct of another if he or she is a party to a conspiracy to commit a crime and hires, urges, counsels, or plans with another to commit a crime. So even if you're just that conspirator to a crime, you are responsible for the actions that result out of that crime. So you're just as liable as the person who was the principal in the first degree. The accessory parties to the crime, an accessory before the fact was a person who, knowing that a crime was to be committed, aided in the preparation for the crime, but was not present at the time the crime was committed. So this was someone who just worked with the planning of the crime itself, but did not in any way participate in the crime. They are an accessory before the fact. An accessory after the fact was a person who knew that the crime had been committed and gave aid or comfort to the person who committed the crime. So this could be someone who provides a place for a fugitive to hide. or aids the fugitive in getting away from the police. Those are accessories after the fact. Neither an accessory before the fact nor an accessory after the fact could be tried until the conviction of the principal in the first degree. So the principal in the first degree had to be convicted prior to the accessory before and accessory after the fact could be tried. That was all under common law, though. Today, parties to the crime, their criminal liability is much different. Today, the common term is accessories, and parties can be criminally liable for the whole criminal conduct regardless of their role. So what one did, they all did is the concept. The rule that all parties to a conspiracy or other agreement to perform an unlawful act are liable for every action taken by any party in the furtherance of the conspiracy or agreement. So the example that the book gives was the defendant Watts guarded the parents of a teenage girl while his two friends raped the girl. Watts was convicted of 2 counts of rape in concert because he aided and abetted both rapes. Even though he didn't participate, he aided and abetted them. So he was guilty of the rape as well. Under the common design rule, when people have a common plan to do an unlawful act, whatever is done in furtherance of the common design or plan is the act of all, and they can all be punished for that act. So the example the book gives, this is an interesting one. If one of the parties to a drug trafficking offense carried a gun, then all the parties are subject to the penalties of carrying a loaded gun while trafficking marijuana. So even though they didn't have a gun with them, because one of them did, they all can be subject to that criminal liability. Another rule you're going to want to know, under the Pinkerton rule, a co-conspirator can be held liable for the crimes committed by another co-conspirator, even if the co-conspirator did not know about the other crime and did not agree to commit the other crime, so long as the crimes were committed in furtherance of the conspiracy and were foreseeable. So a person can be guilty of unforeseen acts during the commission of a crime. Finally, post-crime offenses. So post-crime offenses pose criminal liability and are actions taken after a crime has been committed with knowledge that it has been committed, which provide aid to the person who committed the crime. So this is the aiding and abetting the fugitive. So obstructing justice, false reporting, failure to report a known felon, harboring or aiding felons, communicating with jurors with the intent to influence them. All of that are post-crime offenses that you can be criminally liable for. They're designed to assist in the functioning of a smooth criminal justice system, which is what we all want. And I look forward to the Chapter 5 coming up after this.